And that is because there will be a number of other students who will not be able to join us for the tutorial. So let me first of all begin by welcoming all of you to tonight's tutorial. This is our first tutorial session for administrative law, and I'm very excited to see 24 students joining a tutorial in administrative law. When I was teaching administrative law in term 2, I would usually only have 2 students attending, even from the very start. But this time, I'm so excited to see 24 of you. Wow, it's like 25 including myself. So it's great. It's like I enjoy having a tutorial when there are more students, and if there are fewer, it's not like I don't want to do my job, but it's just like it's better when there is an opportunity to engage with more of you. So I thank you for being here, and I'm hoping that you will continue with this. This becomes a practice, and you will continue to join the future tutorials that we hold on Thursdays. I also noticed that a number of you have actually been my previous students in constitutional law, and I think some of you may have actually taken public international law as well. So this is really exciting. So welcome to our first session, and welcome to term 3 for 2017. Now, how do we begin? Do we go back straight to objectives? Let me just cover briefly what I intend to cover tonight, and then we can then discuss other things. So after this session, you should be able to explain the purpose of the tutorials and how they will be ran. I'd like to explain that. I'm also hoping for you to be able to understand the requirements for success in the unit, then elaborate on the requirements of the key assessments in order to improve your marks, and discuss and explain aspects of administrative law. And I'm going to dispense with that for now. So let me begin. Before we talk about what is to be expected in the tutorials, there's actually something I've been playing in my mind, and I'm going to share it with you. I'm somehow fascinated with this idea about happiness. I'm not sure with a lot of you, but I've actually been doing a lot of reading on happiness, like, what makes people happy. And I've probably been delving on that question because about 2.5 years ago, I separated from my ex-wife. And that was a very difficult time for me. I was actually clinically depressed. And I had to find ways to get out of my depression. And the way for me to do it was actually to look for evidence-based strategies to overcome depression and be happy. Now that theme, the theme about people being depressed, the theme about having a desire to be happy, I think is commonly held among a lot of people. And the research suggests that depression is actually quite present among law students and even among lawyers. And I'm not really sure why, but you probably have a sense. Some of you may not have had to go through that, but from research and a lot of studies going on, a lot of students are depressed or they struggle emotionally because of the requirements of doing a law degree and pressure and so on. So so as I said, I've actually been reading on happiness. It's kind of a pet topic for me. I've read a lot on the topic. Now, typically, the idea, I think, is that for a lot of people, the idea is that if they become successful, and you can define success usually in terms of career success, financial success, becoming wealthy, having a good career, having a good job, then they believe that they would be happy, right? I mean, if you're financially successful, then we assume we will be happy. And so therefore, a lot of people, chase all these dreams. A lot of people are willing to sacrifice and give up their happiness of today for that happiness in the future. But research also suggests that when people do arrive at that place, when they become financially successful or successful according to standards set by society about having a good house, having a nice career, having nice cars, and probably having a lot of money in the bank, then these people realize they're not happy after all. And so therefore they chase that next set of things that, or achievements that they think can make them happy. Now, a lot of studies, on the other hand, suggest, and this includes studies by Professor Paul Dolan, and it is that it's not so much about success leading towards happiness. In fact, it is about happiness leading towards success. In other words, those people who are happier or who find ways to be happy. And according to Professor Dolan, it's about making a decision to be happy, designing things to be happy, and then doing those activities. So it's about behavior and activities that make you happy. So according to Professor Dolan and a lot of research by Emma Seppala and so on, when one is happy, the likelihood of success is actually higher. Now, I raise that point because what I was thinking, and it all depends on whether you like, whether you may be interested, what I was hoping to do is actually to spend about maybe 5 minutes of a tutorial, and I could do that not between 7 to 8, but probably a few minutes before, let's say from 6:55 to 7, where I'll spend a few minutes just talking about certain things we should be doing that will lead towards happiness, and then we'll do some reflective exercises. The idea being that, and this is my theory, and this is, I'd like to test it in a laws unit. The idea being that if we can make students decide, design, and do activities that leads towards happiness, then perhaps not only are they going to be happier in their personal lives, but they're likely to be more successful as students, and perhaps make them actually help them complete our unit or other units in the LLB program. That's my theory. Let me begin with that. What is the thought? Can I just get some ideas from the class? What do you think?
Hi, Manjo.
Yes. Pagan, hi.
Hi, how you going? I do think it's very important for students to have good mental health and to engage with each other. And sometimes it's the little things, like when your friend pulls you inside and says, "Hey, Pagan, are you actually all right?" And then you have a chat with him, and it can make your day go from like here to like way up here. Simple things like that, just checking in with each other also helps. But no, I think that's a great concept, and I just wanted to add in on that. So thank you.
So I've noticed a message here from Tash and from Sylvia that they think it's a good idea. So would there be any serious objections to me kind of, interposing some segments, part of the session devoted to the scientific evidence, scientific-based workshops or sessions about, happiness towards success as a law student? Would there be any serious objections to that? So I'll start the session maybe at 6:55. And then, we'll do some reflective exercises. But what I'm hoping to do is that instead of the typical, what I usually do, process whereby, we start talking about administrative law and just go deep into the topic, why don't we make it a more, how do you call it, knowing that there is actually a person, there are persons with real lives, with problems, and with challenges that are being faced each time. And so therefore, by talking about this, so there wouldn't be any objections. Would that be fine? So I could prepare for it because I don't want to impose it. Would that be fine? Okay, very good. So no objections. Very good. So starting next week, 5 minutes before class starts at about 6:55, I will say a few things about happiness, and I'm speaking of evidence-based and the literature, and I've really read a lot on it, and kind of encourage you to think about these exercises and the research, and I'll come up with specific strategies, and there are lots of them. And I'm hoping that by doing that, we go into these tutorials with a different sense of, not just talking about the law itself, but knowing that we cannot divorce trying to learn about the law from our real lives, that, we have lives. And the way problems that we face and so on can impact on our lives as students as well. Okay, then. So I won't spend more time beyond what I've already said. So thank you. I don't see any objection there. So therefore,
And if you give us the answers to the end assignments, we'll be very happy.
sorry, Peter, I kind of missed that. What was it again, Peter?
Sorry?
Sorry, I missed what you said. I have a problem with the sound system.
Sorry, I was just saying, give us the answers to the final exam and we'll be very happy.
Oh, yeah. So I'll make it easier in the sense that I will provide as much guidance as I could. I obviously can't give the answers, and you probably don't need it anyway. But if I tell you, I know you're joking, but if I tell you the core concepts that will be assessed, and then provide some guidelines, I don't see any reason why you will have difficulties in doing the final exam. So don't worry about that. Okay, so let's talk about the tutorials. Now, let me begin by saying that as far as the tutorials go, of course, the focus on student learning. So this isn't my session, this is your session, and you're here because you want to learn. And I'm going to do my best to facilitate that learning. And I realize that learning is not just about building concepts, understanding certain concepts, but I know that the emotional side of things, having a learning environment that's conducive to learning is equally important. So my focus is on you, and I always emphasize that the learning environment should be safe in the sense that even as we discuss administrative law concepts and we have questions that are being raised, be free to express your thoughts. Some of your answers may be wrong, and I will provide feedback, because otherwise, if I don't provide feedback, you wouldn't know if what you have said is right or wrong. So I will provide feedback, but it will always be very constructive in the sense that it's not so much about you, but about probably saying something about how you answer can be improved. So the purpose is never to embarrass you, but the purpose is for us to learn. Because if I keep on just saying, what you did is correct, even if it's wrong, then you're not going to learn. So realize that my goal is to have a safe learning environment. Okay, I'm just checking that I'm recording. The tutorials are actually also meant to dig deeper into the concepts and cases. So you should be reading the textbook, you should be reading the study guide, watching the lecture podcasts. But a lot of what you read or a lot of what you view would probably lead towards, in a sense, a very superficial learning, because it's kind of you're just reading it or just watching it, and the opportunity for you to dig deep into what you've read or what you've watched would probably less. The tutorials provide opportunities for us to really dig deep into concepts and cases. And so therefore, that's the reason why we have tutorials, so we can dig deep. Not only do we know more about the concepts, but actually we're developing certain skills such as how to identify the issue, how to be able to identify the rules, how to apply the rules of the facts, and come up with a conclusion. So you don't learn this, obviously, by just reading a textbook, but knowing how to articulate your answers and think in a very logical way, it's something you will learn in the course of tutorials. The tutorials also provide you an opportunity to practice giving oral answers. Now, some may wish to become a lawyer, and they're thinking that they just have to write pleadings, do research, without having to argue cases in court. But it is always better to, have a lot of opportunity to do an oral presentation, because you'll probably get a lot of chance to appear in court, or probably talk to your client or talk to another counsel and so on. So the tutorials provide you an opportunity to practice speaking in public without having to be embarrassed, even if you end up saying something wrong. And as I said, these will give you opportunities to receive constructive feedback, not only from me, I suppose, but from your fellow students. Okay, any questions so far before I continue? Okay, none. Now, as well, let me talk about requirements for success. This is probably quicker. There is no shortcut to success. I'm really hoping that you consistently prepare, study, and work hard for our unit. And at the minimum, I'm hoping that you at least read the textbook and not just the study guide. this is important because the study guide cannot take the place of the textbook. I mean, for one chapter, for example, the study guide that I prepared, it's just, a number of words, and the discussion of any topic or the concepts is, of course, greater and more comprehensive in the textbook. And so the textbook is a guide. The study guide is a guide, but you need to read the textbook. Okay, so that should be clear. I'm also hoping that you read the cases, because if you don't, I mean, the advantage of the cases is that the cases obviously articulate what the law is, because we are in the common law. So now we are in a system of common law. And so it's not all about statute. It's also about how the courts interpret the statute. And in those cases where the statute may be silent, then the common law steps in to tell us what the law should be. And the cases are important because by providing the facts, it helps us appreciate how certain legal principles actually come into play and how they should be applied. So the cases are important. I also suggest that you need to work ahead and plan for emergencies and disruptions to study. So, moving forward, you will have emergencies and disruptions for whatever reason. It could be because of work commitments, could be because of family commitments, and so on. It'll be better if, early on, you've already planned ahead. You will also need to learn to do the IRAC format of answering case problems for the final examination. So we will devote sessions to helping you do the IRAC format. And for a number of you, I think, you would also have been exposed to the IRAC method in a lot of other units in our LOS program. So I will spend a lot of time as well on how to, helping you develop your skills in terms of doing the IRAC method. I've already discussed happiness for success, so we will spend time on that as well. Now, let me just quickly go to the assessments. And then I need to discuss something about the case notes, because it can be a bit tricky. Let's talk about the assessments. There are 3 major assessments for the unit. We have 10 weekly online quizzes, so there'll be 1 quiz for each week, starting tomorrow. But the quiz for tomorrow actually corresponds to the week 2 topic. So we might say that the quiz actually begins with the week 2 topic, and that it moves on towards the week 11 topic. So we've got 10 weekly quizzes beginning with the week 2 topic. And the details about the weekly quizzes are, of course, in the unit profile. Let me skip the case notes and I'll go back to that. We also have a final examination. In the past, what we had was a final take-home paper, but there has been a change in the LLB program, in the sense that the, how do you call it, the CALD, the Council of Law Deans, the Council of Australian Law Deans, as well as the LAPB, the Law Admissions Practitioner Board, have began to introduce more requirements in relation to assessments. And they have raised so it will be an invigilated exam, Emma. So the CALD and the LAPB have come up with requirements that before they will accredit or renew the accreditation of certain laws programs, especially the online ones, they need to see more evidence that it is students themselves who are actually taking the assessments. So they're not very comfortable with the idea of just purely final take-home papers. And so for this reason, this policy has been adopted in our LLB program. And therefore, starting this term, and especially starting in term 1 of next year, you will notice that all the priestly 11 subjects will move towards invigilated exams, and the final take-home paper will no longer be permitted. So that is now a policy. It doesn't come from me. It did not come from me. I know it is a bit inconvenient for students, but it is a requirement. It is a condition that has been set by the Council of Australian Law Deans as well as the LAPB. And as a result, we've had no choice but to change our practices in relation to the final assessment. So the final assessment is a final invigilated examination. So I don't know when the schedule will be, because that will have to be announced by the university. But as I said, it shouldn't be too difficult to pass the final examination or to do well, because I will provide guidelines and assist you with the with the skills on how to do the IRAC format closer towards the final examination date. Did anyone wish to ask a question so far?
Manjo, it's Monique.
Yes.
I just had a quick question about the final exam. I did read on the unit profile that it's 4 problem questions. I just wanted to know, having done a number of take-home papers in the past with a similar amount of questions, and obviously typing them, would you make changes to accommodate the fact that A, we're handwriting, and B, we have strictly limited time frames in how you structure your questions and how you expect people to answer them?
I don't think there'll be any changes as to the questions that will be asked, or the kind of questions that will be asked, or the length of the questions themselves. I don't think there will be any changes. So, the type of questions you would have seen in constitutional law, and when you see the past questions I've had for administrative law, because you're going to get the chance to see them, because I'm going to put them up, including some exemplar answers, there won't be any change as far as the questions that are being asked are concerned. There will obviously, however, be a change in terms of my expectations as to what an ideal answer should be. Ideal in terms of what is an HD and what seems to be just a pass. In the sense, number one, that there's likely going to be no need for complete referencing. So better if you could reference, but if you cannot, that's fine. If you're able to reference, that's added mark, but for as long as you're kind of able to cite the law correctly, even if you don't reference at all, that is fine. So that's one. Secondly, because of the time constraints and the time pressure, the quality, or maybe in terms of the length of the answer itself, I know that the answers are likely to be shorter. They're likely to be concise, shorter, concise, direct, to the point. So it won't be like a treatise, Monique, when you gave me your answers in constitutional law, which was like, you wrote a textbook, and of course there was 100 out of 100. That's not going to happen in a final exam because, we've got a shorter time. So it's possible that an answer that will just use up, I don't know what you're using. Do you use some kind of a notebook for the final exam? Is there a notebook? How do you call it?
It's just paper in a stapled notebook. Yeah.
So there's a paper there. I would imagine that if you fill up that paper and fully, use it up, or even part of it, I don't see any reason why somebody who does that does not get, 100% for a particular question, whatever that might be, like 25 out of 25. I don't see any reason why not. For as long as that student is able to do the IRAC properly. In other words, identify what the legal issues are, identify the rules, apply the rules to the facts, and come up with a conclusion. So it's going to be a shorter version, but direct to the point. Okay, so there is a change, therefore, in expectation.
Thank you.
Yes, you're welcome. Now, from Kyla, I don't even know how to reference in an exam. Well, at the very least, what I will point out later on is that, and I go back to the case notes in a short while, is that there are actually some really important cases in administrative law, just as there are really important cases in constitutional law. So not all cases are actually of equal importance. There are some that are really extremely important in administrative law. For as long as you're able to cite the case, that should be fine, without even having to go into the actual citation. So in relation to the invigilated exams, Leonie, is actually really just for the pre-state 11 as of this time, although it's really discretionary on the part of the unit coordinator to decide the type of assessment. But we have agreed that starting mainly in term 1 and starting for some of us in term 3, we should already be adopting an invigilated exam as the form of final assessment. Okay. Questions so far on the final exam? None? Okay, moving on. Let's go to the case notes. So the case notes, to me, provides an opportunity for a student to appreciate certain legal principles by being very familiar with certain cases. this allows you to have a deeper understanding of the law, particularly about administrative law, by having a very thorough understanding of a particular case. Now, writing a case note, and I'll provide more guidance later on how to write a case note, but writing a case note enables one to not only read the case superficially, but then to translate and put into words one's understanding about a case. And doing so provides an opportunity for a student to have a deeper understanding of the law. And that's the reason why we have case notes. And I think that case notes can, in certain circumstances, be superior to just having a problem-based question. Because again, if it's just a problem-based question, the problem there is that there's the opportunity for a wider depth of coverage of legal concepts, but wider breadth, but not so much in terms of the depth. The case notes allow you to really dig deep into what a case is and what its significance might be, and it is likely to be something that you will continue to remember further on, not only in this unit, but when you practice law. Now, and of course, there will be a presentation where you'll be required, I think, where you're given 3 or 5 minutes to actually do a presentation about a particular case. So that will be in the unit profile. That's not important. What I wanted to point out is that as far as the case notes are concerned, you will be required to individually to write 3 case notes. Now, if you were going to work as a group, if there are 2 students in a group, then you will have 6. If it's 9, you will have 9 case notes. Now, what is important is that whether you're doing this assessment individually or as a group, you can only pick 1 case from each weekly topic. So you're not permitted to write case notes on 2 cases pertaining, for example, to week 2. That's not permitted. It has to be 1 case note for each weekly topic. So if there are 3 students in a group, it means you need to cover 9 weekly topics and come up with 9 cases corresponding to those 9 weekly topics. Now, initially what I had in mind, and this is where I'd like to ask you a question here. What I initially had in mind was that, we're going to develop a database of case notes, which would then provide a source of learning resource to students. And therefore, the best way to do this would be, I think I identified about 170 cases. I came up with a Microsoft Word, which is in Moodle yesterday, put it up. There are about 170 cases in administrative law, which I'd like students to work on, or give students an opportunity to work on. And one approach is that, we make sure that all those cases are written on by students. That is one approach. But in order to do that, what would then happen is that we kind of find a way where there is no duplication. Now, there is a logistical problem for that, because the first logistical problem is how do I find a way that students do not duplicate? So I'll probably have to say that is it going to be first come first served basis, or do I say put up something online and the first set of students decide which one they'll take, and once that has been taken, other students can take it. That's one approach. The other possibility here is that I will allow the students to just decide what case they'd like to write on, even if it leads towards duplication. My concern about ensuring that there is no duplication, my concern, first of all, is that it may be too complicated to make sure that there is no duplication of case notes. It might be very difficult to do that. But secondly, I'm concerned that some students will then say that he or she was assigned a case that is actually more difficult to write on compared to another. Somebody can say, but that case is shorter. My case, so that case is probably just, has only 5 pages. Mine has 120 pages. That is my concern. So the question I have is, should we just allow students to choose whatever cases they'd like to write on, instead of assigning unique cases to each student, or giving them an opportunity to just write a case note on a case that no one else would be working on. That is my question there. What do you think?
Can I make a quick suggestion, Manjo? Could you do a combination of both? So each student could select 2 that they wanted to work on themselves, and you could select 1 then from the leftovers that haven't been addressed, so that you're making sure there is some kind of variety in there, especially considering if we have to do an oral presentation on it, perhaps it is that one that you're assigned that you could present on, because then you wouldn't have 20 or 30 people presenting on the same case.
Possible. The only problem, I go back to my problem though, what if there are some cases that have been assigned that for some students are comparably harder to write on as opposed to another. So they might say there are problems there with equity because, you know what I mean? Somebody is working on a case that's only 5 pages long, another one has to deal with a case that's 120 pages long. And that can lead to kind of equity issues.
Can you identify some that are on an even keel, for example, and then those be the ones that you distribute, and then with the others that people choose themselves, well, that's their own perspective. That's their own choice. Anyway.
That might be also difficult, because at the end of the day, it's not just about the number of pages. It's actually the complexity of the principles involved. I might say that it's easy, but actually it's kind of not easy according to a student's view. So perhaps I understand. My thought right now, I just felt like I needed to consult you. My original thought was to make sure that every single student works on a unique case, but I'm actually tempted to just give students the opportunity to choose and pick, and to choose and pick, even if there would be some duplication.
Manjo, can you sort of divide the cases into, well, you yourself identify which ones are the hard cases, which one are sort of the middle of the range, and which ones are the easy ones? And then,
okay,
people may choose to do the harder stuff because they're into it, and then that's up to that. But I suppose you run the risk of then having everyone choose to do the easy and nobody wants to do the hard.
Yeah, okay. Yeah, so perhaps what I can do,
Manjo,
yes,
sorry to interrupt.
Yeah.
Another thing too is, and I'll harp back to a previous torts presentation where we all had to go online and give a 5-minute spiel online, basically on the same subject.
Oh, okay.
And for the ones that I saw, and the detail that each student put into it was different in every case. So even if we get the same case note to write, I would hazard a guess that not one would be the same as the next one.
Okay. So why don't we just simplify this? Understand that I would have wanted, for the purpose of developing the database, I would have wanted that there should be, each student should only be working on a unique case, but to avoid the problems, issues about equity and so on, I'll probably just allow students to choose and pick. What I will do, however, is to highlight what to me are the really important cases, which will likely be assessed in the final examination. And in that case, but again, that leaves all the students ample opportunity to decide which case to pursue anyway. So I think I'd rather not, for now, I don't see the need to kind of assign students to do particular cases, but I will come up with a suggestion on what I think are the really important cases for administrative law.
Or Manjo, I know that this is still just getting thrashed about at the moment, but what about if you assign 1 or 2 and we get to choose what's left? You know what I mean? Like, so that if it's 3, you assign us 1 and we choose 2, or vice versa, something like that, so that we still get, but some choice, but also there's a spread of cases.
Okay. So why don't we do this? I think I get the sense that some of you, or most of you, actually like the idea that there should be some uniqueness in the cases. So what I'll probably do, following that, what I'm going to do is to allow students to choose at least 2 cases, if that's fine, whatever it is, and then I will come up with a set of cases which I will assign to students at random. And in the end, if a student feels that that particular case is a bit too difficult, then I'm open to a student doing something else. But the goal is that there will be a set of cases which each student will be working on uniquely. Would that be fine? So which means, therefore, that there will be some cases which will be uniquely written on by students. So 2 cases where students can decide what to write on. And then there'll be a third one which I will assign at random, but giving the student an opportunity to change the case. Would that be fine? Happy with that?
If I can quickly weigh in, Manjo,
Yes.
I think I put the post there. I think what you said is a fair compromise, but also understand that I think someone said it before, that what we're talking about, what we're discussing is only very minor marks for the whole course. The examination's worth 60-odd%. What we're talking about here is only worth a very small percentage. So let's not thrash it to death. I think the fair compromise has been met.
Okay, very good. So that's what I'll do, 2 + 1. Okay, but the case notes are actually worth 30%. Okay, so that's what we'll do. Thank you. So having discussed that, let's briefly talk about administrative law. Before we go to the tutorial questions, which are actually in Moodle, one thing I'd like to emphasize is that administrative law is probably an area of law that a lot of you will confront every day. If you speak about constitutional law, for example, the likelihood of any of you really, getting involved in constitutional law is actually quite limited. It's a very specialized area of law, although it helps you to have the knowledge, but to be practicing in the area of constitutional law and that it actually directly affects you as an individual or as a citizen is likely to be less. Administrative law, however, is something that is likely going to affect you and will assist you, because anything we do today is actually affected by decisions made by the executive. So when I speak of the executive from the viewpoint of the Commonwealth, I'm talking about decisions made by the Prime Minister and his cabinet and all the other people in the executive department, whether they're secretaries or heads of executive departments and so on. They make decisions about benefits that we could receive. They make decisions about taxes we should be paying. They make decisions about child support. They make decisions about whether or not we should be given a license to do something, like a license to practice law, a license to do this or that, a license to drive cars, a license to engage in certain regulated activities, and so on. All of these activities that I mentioned actually rest on decisions made by the executive. So for those who may not have had a chance yet to take up constitutional law, there are 3 branches of government. You have the executive, which we typically see from the viewpoint of the Commonwealth as being the Prime Minister and the Cabinet. You have the Parliament, which is composed of the Senate and the House of Representatives, and we have the federal courts. If you look at it from the level of the state, you normally talk, at least in Queensland, you would talk about the executive being the Premier and the Cabinet of the Premier, and then you have the Queensland Parliament, and then the state courts. The focus of administrative law is actually on the decisions and actions of the executive that affect individuals or affect corporations. And administrative law, therefore, provides an avenue for people to contest decisions or actions undertaken by the executive. That's what administrative law is about. It also talks about opportunities for people to seek more information about public documents that are in the possession of public officers. It also talks about opportunities to go to the ombudsman, internal review processes, and so on. And so therefore, at this point, I'm hoping you get to sense how important administrative law is. So having provided that background, which to me, and as I see it, as administrative law being important, what are your thoughts about what administrative law is about? So I'm not talking about asking you to make a definition of administrative law. To you, what is administrative law about?
For me, it's about high-level government decisions.
Mm-hmm. Very good. Others?
Keeping government accountable.
Very good. Do you suppose administrative law is important? Is that a question there? Okay. Okay, let's discuss that a bit more. What else is your idea about administrative law?
I think it gives people a voice because it gives them that avenue to keep the government accountable and to be a part of those decisions rather than, like I think you said one of the lectures, rather than it's not just waiting for an election, there is something that you can do in between voting.
Have any of you had experiences of some decision made by the executive, whether from the viewpoint of the Commonwealth or of the state, which affected you personally? Any decision or action of the executive, and perhaps you may want to share that with the class, so we just get a sense of what are examples of executive decisions or actions that affect us. Grant,
Yeah, if I can, it's an odd one, but it's a personal thing too. My father served in the military for 42 years, from Vietnam through Afghanistan, and I served in the military for 10 years, Iraq and Afghanistan. Now, when I was discharged from the military, the Department of Veteran Affairs said, yep, Grant, you've served your country, you can get all the veterans benefits, we give you all the money, everything, look after you, well done, well done. And I said, no, I still want to keep working. But my father, who was older and served for longer, he was told that he was ineligible for benefits.
Oh.
By the Department of Veteran Affairs. He didn't fulfill the requirements.
I see. Yeah. There you go. That's an example of a situation where administrative law comes in. You might be surprised that in those instances where a student, for example, is not permitted to graduate from a public university in Australia, there might arise an instance where administrative law comes in. Somebody who's been accused of plagiarism, somebody who's been accused of academic misconduct and so on, administrative law can come in to the picture if it involves a decision by a public university. Yes, Gay.
Sorry, without being too much of a sticky beak, Grant, can I ask, do you feel like there was enough of an avenue there for any recourse, or dealing with the Defence Force can be a bit of a brick wall sometimes?
Well, to be brutally honest, it's not completely over. You can probably Google my name in Australia and come up with the case, the case file. At the time, no, there wasn't any sort of avenue for appeal, but that is now changing. So, it's not a complete end story yet.
Okay, thanks, Grant, for sharing that. Can I go to question 2? And what we're doing right now, because we're not really going deep yet into administrative law. It's kind of just getting a sense of what administrative law is about and why it's important. We're going to be talking about judicial review. We'll talk about merits review in the succeeding weeks, or at least in week 2. But for now, because it's the first week, and even when you look at the textbook, we're essentially just broadly talking about administrative law. And I realize that there is a chat going on about the invigilated exam. I'll try to address that later on, but I'll just focus on the tutorial questions. I'm aware of what's going on there. There's a chat, thank you for that. But I'll just focus on the tutorial questions in the meantime, if that's all right. Now, why do you think it is important to study administrative law?
Well, it shows you, for example, that there is a chance to have your voice heard and make a difference rather than just sitting back and being part of a dictatorship.
Very good. Thank you, Rob. How about the others? Why is it important to study administrative law? Gay.
Because when you look at the list of where the government comes into your life, it pretty much doesn't stop and you really can't avoid it even if you tried.
That's true. Yes, Grant.
I mean, I probably don't know as much as others in regards to admin law, but it seems to me like admin law is or has been quite pivotal in updating and creating new law and modernising our law. And it also appears to be very much a backbone of democracy. It's giving a formal voice and process back to the people rather than what Rob said, where it's bordering on democracy, bordering on a dictatorship.
Right. Very good. Thank you. Others? Put it this way. We know that the government makes decisions every day, and we're talking the executive government, and those executive decisions do affect us. And they can affect us in terms of, Centrelink benefits. They can affect us in terms of child support decisions. They can affect us in terms of what medical benefits we can receive. They can affect us in terms of, for some who might want to get married, or invite somebody who can become an immigrant to Australia. Those are decisions made by the Minister for Immigration, for example. They can affect us. They can affect us, as I said, in terms of licensing and so on. Now, imagine if in the past, before the development of administrative law in the 1960s, beginning in the UK, what would then happen was that if a person were unhappy with a decision of the executive, because that decision affected that person in particular, what that person will have to do is actually to have to go to court. And when you think about it, you can just imagine quickly how having to go to court can be costly and difficult, because if you go to court, you need a lawyer. You can't be representing yourself, because you need a knowledge of the law to actually kind of contest a decision made by the executive. And so therefore, if you get a lawyer, it can be very expensive. What has happened was that in the 1970s, and primarily with the enactment of the Administrative Appeals Tribunal Act of 1975 Commonwealth, and subsequently the development of the passage of legislation pertaining to administrative tribunals in the States, what has happened was that there has been a new avenue for recourse if one wishes to contest decisions of the executive. Now, going back, not only the problem with judicial review before was that not only was it very expensive and costly, you needed to have a lawyer and so on, but if you wanted to contest a decision, or you wanted to have a decision made by the executive reviewed by the courts, it was limited only to questions of law. So if you disputed the findings of the executive, there was no avenue to go to the courts in order to question the incorrectness of findings of the executive, because courts, especially the federal courts, they can only review decisions of the executive on questions of law, but never on questions of fact in general. With the passage of the Administrative Appeals Tribunal Act of 1975, what has happened is that the Commonwealth, and then eventually the states as well, the Commonwealth, in relation to Commonwealth executives or Commonwealth department decisions, what has happened is that there is now an avenue for decisions made by the executive to also be reviewed on the basis of merits, or what we know as decisions made on the basis of facts, on the basis of the exercise of discretion, on the basis of decisions made on the basis of policy. That is a huge difference, because as far as the courts were concerned in the past, and even today, if you speak of judicial review, as you will later on learn, judicial review is limited to questions of law, and judicial review cannot encompass a review of decisions on questions of the exercise of discretion, on questions about incorrectness of facts, or on questions about resort or recourse to policy. In relation to policy, for example, as we will later on see, that relates to what is known as questions of justiciability. The courts will not step into questions that involve political decisions or decisions made by elected officials of government, because the courts realize that any political decision or decisions about policy are best made by the elected officials of the government on the basis of what is known as representative democracy. And courts will shy away from that on the basis of what are known as justiciable questions. But with the passage of the Administrative Appeals Tribunal Act and the codification, in a sense, of what is known as the merits review process, there is now a tribunal not belonging to the courts, not a Chapter 3 court, not belonging to the federal courts, but belonging to the executive itself. It is a creation of the executive, and the tribunal members all report to the executive, for example. So what the executive has done is to create an administrative tribunal that allows people who are unhappy with an administrative decision to contest or appeal the decision, not only on the basis of problems or questions of law. In other words, even administrative tribunals can actually examine appeals of administrative decisions on the basis of a question of law, although that is not binding on the courts. But they can entertain appeals on the basis of questions of law. But at the same time, the purpose of administrative tribunals is actually to examine factual decisions made by the executive on the basis of factual questions. So that is huge. That is known as the merits review. The administrative decision, the administrative tribunals also have an opportunity to review the use of discretion, as we will later on learn, review the use of discretion or the exercise of discretion by executive decision makers, as well as the way that they would have applied policy. And this is why an understanding of administrative law is crucial, because then it allows you, who will eventually be lawyers, to understand that the recourse to decisions made by the executive is not limited to having to go to the courts, but there is, in fact, a broader way of contesting decisions of the executive. And when you go to the administrative tribunals, it is less expensive. There is a cost, of course, but it is less expensive. You typically do not need a lawyer. It's actually faster. And for these reasons, it has been quite helpful. And we also learn later on that there are internal review processes you can examine. There are opportunities to go to the ombudsman and so on. That is how important it is to study administrative law. Any questions so far before we continue, or comments? Okay, very good. Now we have 3 more questions. Well, do you have an idea? Let's just focus, for example, on the distinction between administrative law and constitutional law. You would have heard that in certain areas, administrative law intersects with constitutional law. So let's just focus on constitutional law. How would you distinguish administrative law from constitutional law? Are they the same? When you study administrative law, you're actually studying constitutional law, or when you study constitutional law, are you necessarily studying administrative law? What are your thoughts on that?
Manjo Ilonka, yeah. I think in administrative law, the players changes opposed to when it's constitutional law and civil law, so the parties are a bit different.
Mm-hmm. Go on.
Okay, so in administrative law, it's basically a way where you challenge those who govern you.
Mm.
With civil law, it can be between a person and a corporation, or corporations or any combination of those. And then criminal, it will be criminal is not in there, is it? Yeah, so I think it's just constitutional. It will be the Commonwealth involved with either the state or it could be a party. Yeah.
Very good. Thank you. Now, thank you, Ilionka, for that. How would you distinguish constitutional law from administrative law? In terms of, the subject matter, for example, what is administrative law about and what is constitutional law about?
Administrative law is about the administration of the law, and constitutional law involves the Constitution itself.
Okay, thank you, Rob. Others, what do you think?
Well, just when you look at the flow charts from the lectures, when you look at admin law, there's people and corporations are part of that flow chart, whereas the examples of how constitutional law works, there was no mention of people and corporations. It was all about the relationships between the legislature or the executive and the judiciary. So the people and the corporations were sort of a little bit left out.
Thank you, Gay. I just noticed the comment here from Grant that he hasn't studied constitutional law yet. So that's fine, Grant. Let me just clarify. So you will notice that as far as administrative law is concerned, the key idea here is that decisions are made by the executive. And so what therefore happens is that as far as the parties are concerned, it's usually the citizen who is then applying for a review made by the executive. So it's the individual or the citizen against the executive. Are we clear so far? In terms of the parties, and as found in a short while. When you speak about constitutional law, you will notice that constitutional law encompasses not just actions or decisions made by the executive, but also it is in relation to the powers exercised by the parliament and the powers exercised by the constitution, by the courts. So constitutional law also examines the exercise of power, not only of the executive, but also of the parliament and of the courts. Okay, so we're talking of, the parties, we're talking of the bodies involved. In constitutional law, you also speak of the exercise of power by the executive, by the parliament, and by the courts, which are the three branches of government. But the other important thing is this. Let's assume that a law has been passed by the Commonwealth Parliament. And then let's assume that the Commonwealth Parliament delegates certain powers to the executive to pass what is known as subordinate legislation in the form of bylaws or regulations. And the executive then, on the basis of those bylaws and decisions, or those bylaws, or on the basis of any regulations that it passes, makes decisions or actions that affect the executive. So let me ask the question. If a citizen felt that there is something legally wrong or constitutional wrong with the law, whether the law passed by the Commonwealth Parliament or a regulation passed by the executive on the basis of what is known as subordinate legislation or delegated delegation or delegated lawmaking powers, for example, is that constitutional law or is that administrative law? So that's good. So we should be clear that if a person seeks to question or challenge the law itself, the law either passed by the Commonwealth Parliament or a regulation passed or a bylaw passed by the executive, that belongs to call in the area of constitutional law, because that is the legality or the constitutionality of a law. Administrative law is limited to the decisions, to the legality of the decisions made by the executive. Can you see the difference? So you have a law, whether law passed by the Commonwealth Parliament or law passed by the executive, law broadly in the sense that it's a regulation or a bylaw. Now, on the basis of those laws, decisions are made. Administrative law focuses on the decisions made by the executive, but you do not attack. You cannot attack the constitutionality or legality of a law. in administrative law because that is constitutional law. So is that clear? So that is a crucial point there. So therefore, if a law has been passed by the Commonwealth Parliament and then a decision is made affecting an individual, if an individual seeks to challenge the constitutionality of a law, that cannot be administrative law. That is a constitutional law question. So you don't go to the Administrative Appeals Tribunal questioning the legality or the constitutionality of the law. You need to go to the courts for that. So are we clear? So just broadly. Now I see it's 8 o'clock. So we need to wrap this up. Any questions before we end tonight's session? And as I said, I wish to reiterate my thanks for having a huge audience tonight. I'm hoping to see more of you. And I can, I'm looking forward to being able to discuss a few things about happiness for success or happiness for learning. Any questions before we end tonight's session or comments?
Manjo, it's just Leonie. Did you talk about when you're putting the quizzes up? Is it next week or
it will start tomorrow? So the first quiz comes out tomorrow. You have 1 week to answer that quiz. It closes, I think, on Thursday. I don't know what time it will be, but it closes on Thursday. And that question will relate with the week 2 topic. Oh, thank you, Gabe, for the comment. Any questions, comments before we end tonight's session?
Yeah, Manjo, I've got one. When are we going to talk about the final exam, just so we can start preparing?
For now, maybe it may be too soon. Don't worry about the final exam. We'll discuss it, closer towards.
Yeah, I'm just thinking about other subjects because I was writing down before this session all the assessment that we've got, and we've got exams for other subjects as well. Where that one we actually already had the dates for, where now we don't.
Oh, that's right. If you're asking about the date of the invigilated exam, it's beyond my control. It's actually the university that timetables that, so I have no idea.
Yeah, well, that's on Moodle that we've got the dates of what the exam was going to be for this subject, admin, and it still says that it's a take-home paper.
Oh, so it was a problem with the system itself, which is why in the unit profile I said disregard the date. It's in the unit profile. So we will know the date of the final exam, I think in about 2 weeks' time, when the university releases the timetable.
Okay.
We'll know then. Okay, so my name is Manjo, Joseph. So a lot of people call me Manjo. I don't know why. Some people call me Mango, but it's Man.
No, it's my stupid computer. iMac, for some reason, autocorrects, and I do it every tute, and I'm
No, Leonie, I'm not complaining. I'm just saying, I'm just speaking in general. A lot of people mispronounce my name, and I understand that because it's an unfamiliar name. That's all right. Okay, so thank you very much, everyone, and I look forward to engaging with you more and to seeing you next week. Have a great weekend. See you soon. Bye.